Good morning. Are you Dominique Lee?
Yes, ma'am.
And this is 25 DCCR 1784. Mr. Lee is charged with criminal mischief from October 14th of 2025. What is the announcement?
Judge, I've talked to Mr. Lee about the situation. I've also, of course, have talked with the state. There is some information I do need to check out in regards to probation he had been recently placed on. And some other things with his criminal history, because especially with that probation, I think that may give us an option to try to get this resolved.
A probation here or somewhere else?
That's
Here.
here, Judge, and we spoke about this, but, I mean, he's got, obviously, through the indictment, it's like it bumps it up to a third degree versus what his.
Bumps it up to a second.
Second, actually.
But if there's, do you show an active? So there would be an MTRP if there was.
I don't have.
All right, I'll reset it so you can figure that out, because if there is a motion, I would assume that there would be a motion to, if there is a probation, I would assume there would be a motion to revoke. So I'll just do a normal reset to give you some time to get all that worked out. If you'll check into it too and see.
I did check prior to coming down, Judge, but I don't have that. It's not in our system. So I'm
Okay.
not sure what.
Talk to probation, talk to him more and see if you can figure it out. Otherwise, we'll go forward with what we got when we come back.
Because my understanding is that is kind of what led us, because he was in custody at the time and then was released when he received the probation. This allegation occurred, of course, inside the jail.
The criminal mischief?
Yeah, this occurred all in custody.
Okay.
So.
Okay. Okay, I'll let you guys check on it and see, what it was, and if you got the probation after the incident. It's okay. All right, we'll figure it out. Y'all figure it out. Okay, go back with the bailiff.
Thanks.
Thank you. And then, Maribel, is it Reichel? Good morning. Are you Maribel Reichel?
Yes, ma'am.
And Ms. Reichel, in cause number 25 DCCR 0664, you're charged with the state jail felony offense of unauthorized use of a vehicle from April 2nd of 2025. What that means is that if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
That, on the rejection, Judge, there was marked something about proceed only on count one, but that was confusing to me.
I just put it at the top.
So is there some criminal history?
There is.
There is. It's just not in the
It's just not
indictment.
In that.
And so what would the criminal history, would it enhance?
No, John, no, Your Honor, but.
Okay, but there's enough, but it would not enhance it.
When it is.
So the state has made an offer, I have a plea bargain rejection that you've signed here with Mr. Lewis that shows that the state's offered 1 year in the state jail if you wanted to enter a plea of guilty.
A state jail felony in Texas still means real prison time, and the judge is doing the "I need you to understand the math" speech, because later nobody gets to say, "I didn't know what I was risking."
You have every right to reject that and have a jury come in and determine if you're guilty or not. And if they find you guilty, you can leave your punishment up to them. I just want to make sure today that you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. And do you understand all of that?
Yes, ma'am, I do.
And do you want to reject that offer and have your case set for trial?
Yes, sir.
All right, we'll get that done. Ms. Reichel, Mr. Lewis has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him. We can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? Okay.
If Mr. Lewis cannot do it, then yes, ma'am.
And he can. It's totally up to you. He's.
Mr. Lewis.
You would? Okay. So Mr. Lewis will remain as your attorney and begin preparation for trial. All right. You can go back with the bailiff. Thank you. See, Ms. Perazzo, you have Thaddeus McCray. Good morning. What are we doing on this?
Judge, we have not gotten this one indicted yet, so we would ask for, I think, both sides of the reset. She is gonna need to look at the evidence on the other case.
When is that gonna happen?
I don't know, I can try to put a fire on
What is the case? Oh,
it. Do you know which one this is?
yeah. Why has it not been indicted?
Don't know.
Even without an indictment yet, the probation case can move because the court is deciding, did you violate the terms? And the judge is basically saying, I'll reset it once, but I'm not babysitting an unfiled case forever.
Well, the alleged offense date was what, December 5th? It's recent. So maybe that's why with closures and
I'll make a
holidays.
phone call and check with the detective this morning, Judge.
Okay. Am I thinking of a different one? Is this the one where the victim and the,
This is the one
Aggravated.
where we started with the sexual assault trial and we got through and we couldn't get the victim to come back. There was a plea deal entered on the aggravated assault and a dismissal on that sexual assault.
okay, this is a different one that I'm thinking of. As far as, I was thinking another murder. Okay,
Then
yeah, I'm thinking something different. Okay, got it. All right, so you're Thaddeus McCray,
Yes, ma'am.
and Mr. McCray is currently on probation for aggravated assault causing serious bodily injury. A motion to revoke has been filed. Obviously, the main allegation is the new offense of the alleged murder. And it's my understanding that it has not been indicted yet. What I'm gonna do is one more reset on this motion. Mr. Smith, I know it's only been less than a month, I guess. Well, a little
A
over
little
a
over,
month.
but
If you'll please get with intake and
I'll try to find a timeline on this.
figure out when, and if you'll let us know that, but I'll do one more reset. But if it's, for some reason, there's some issues, I can't just keep holding this for that. So this will be the kind of the last reset on the motion without some specific information of what's going on that murder case. Okay,
Yes, ma'am.
perfect.
Thank you.
You can go back with the bailiff, sir. Hopefully, soon Ms. Perazo will find out what the status of the murder case is. Once it gets indicted, she'll get all that information. Then we'll see where we go with your cases. Okay? All right, you can go back with the bailiff. See, Mr. Smith, did we lose Mr. Bruce? Bruce Smith, sorry.
I think we've got a resolution, Judge, he's talking about.
Thank you. And then, have y'all seen Joel Vasquez?
He was just here, Judge, I think he stepped back out.
Okay.
I'm still looking for more.
Oh, and Marcus. And then, hold on, what I do with this page, right? Mr. Bynum on Louisa Magruder?
Yes, ma'am. May I approach?
Yes, sir.
Good morning.
Good morning. How are you?
Doing fine, thank you.
Yeah, let's get everybody.
So,
Ma'am,
Never mind.
hang on just a second. All right, ma'am, you're Louisa Magruder?
Yes, ma'am.
And Ms. Magruder is currently on probation for sexual assault of a child in cause number 16-25158. Motion to revoke probation has been, or motion to revoke unadjudicated probation has been filed. And Mr. Bynum, do you have an announcement?
yeah, if we could confer with the court perhaps about if we, I mean, we're ready to clean out True and all of that, but I've been speaking with, this is my first time appearing on it.
Sure.
Ms. Magruder, if I can just introduce myself and why I'm here. And, little known fact about Ms. Magruder is that she's actually one of the class plaintiffs in what is still the largest civil rights case related to bail in the history of the country, in federal court here in the Southern District. So she sued Harris County, the judges, regarding the misdemeanor bail practices. And I know her because I was one of the judges she sued. And, but I agreed with her, which, as a criminal lawyer, I don't have much of a conflicts practice, but this was a pretty funny one.
8 years into a 2-year probation is wild. That usually means repeated violations, extensions, or multiple resets that kept this alive way past its original timeline. Judges hear that and think, you've had chances.
So, the lawyers in that case called me and asked me to try to take care of her here. And what I say about being on an MAJ is that I'm the last to the party. You know, that everyone here has been here on the case for much longer than me. It seems to me that she's she's 8 years into a 10-year probation and has put down many years of sobriety in there. She's responded successfully to ISF in 2020.
Let me stop you, because I guess just as far as kind of procedurally,
Yeah.
if there is, the way I'll handle all of the motion to revoke. So, if there's an agreement, y'all can get that taken care of, do paperwork for whatever's gonna happen. If there's not an agreement and you wanna argue for me to do certain things,
Right.
then what I'd rather do is go through the motion, get pleas of true or not true, and then what I do is reset the case for a sentencing hearing. So everybody has time to provide whatever information they want, bring any witnesses they want. Probation will do an updated pre-sentence report that'll give me more information, and then I'll listen to all of that on that day.
Okay.
Okay.
I understand. Could I just add where I was going with what I was saying, and I'm sorry I'm long-winded. I was wondering if the court would consider, she has a TRAS from last May that recommends substance abuse treatment. I was wondering if the court would consider, with the consent of the state, amending to safety.
So what would happen is I would still get an updated report, because I need to see what all if they agree to that, then yes, I will consider it. So if y'all have an agreed recommendation, yeah, she cannot go because of I didn't think her underlying offense, she's not eligible.
Judge,
So-
just to let the court know, and I don't want to interrupt.
No,
but-
please.
And the court knows the history with this, but
Yeah.
back in June of 24, we did where the court was absolutely will not accept the plea agreement on this.
Okay,
We're not gonna agree to anything because we've done this.
we've been here before. It's unfortunate that I recognized Ms. Magruder over the last few years, and so apparently I have,
We've given,
so,
twice we've actually given it.
okay, so.
Compliance, very strict compliance.
All right, so here's what we need to do then, based on that, just so that we can all get caught up, is get the pleas of true or not true to the allegations, and then reset it for a hearing. You can provide whatever you need, argue whatever you want, bring whatever witnesses, state can do the same. We'll get that updated report, and then I'll make a decision what to do. Okay?
Well, I'll enter pleas are not true.
So let's do this then. Ms. Magruder, please raise your right hand the best you can, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down. And will your client waive the formal reading of the motion?
Yes, we will.
Okay. Let me get this pulled up. So, Ms. Magruder, in cause number 16-25158, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation January 29th of 2018 for sexual assault of a child, a second-degree felony, and that was a 10-year deferred probation. Is that correct? And then it alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department on May 23rd of 2025 and to the administrative hearing on June 2nd of 2025. And is that true or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true? Count 3 alleges that you failed to submit to alcohol and/or drug screening on June 2nd, May 28th, and May 19th of 2025. Is that true or not true? Count 4 alleges that you're behind in your court-assessed fees as of June 2nd, 2025, in the amount of $8,645. Is that true or not true? And then count 5 alleges that you failed to enter and successfully complete the Jefferson County Drug Intervention Program, JCDI, and that's from the order from September 24th of 2024. Is that true or not true? All right, so I will have pleas of not true entered for all 5 counts. Again, we'll reset the case for sentencing, and I will ask for an updated pre-sentence report. Obviously, anything that you think is important for me to know, get that information to Mr. Bynum. He'll present it to me on your behalf on that date. All right, we'll see you back on that date. Thank you.
Smith.
And I'll send it to you.
So it looks like I've got Mr. Smith, Mr. Vasquez, and Mr. Wilkerson. No.
We received information that
I had a 250-second.
Gotcha.
Sorry about that.
All right, so Mr. Wilkerson has Romeo Johnson, Mr. Coleman. Thanks for running it down.
Yes, ma'am.
It sounds like you literally did that.
Mr. Coleman.
Oh, look. And I'll text them what Sorry, I just.
So. I just found, I was looking at the text as I was.
And what about Joel? Is Joel coming?
He was here and now.
Oh, yeah, that's right. All right, so you're Romeo Johnson.
Yes, ma'am.
And Mr. Johnson's cases are set for trial to begin with jury selection next Monday, was the announcement.
We're ready, Your Honor.
Case ready for trial. Judge provided how the court rules on a certain issue, and that issue being we're going forward, or the state desires to go forward on the unlawful possession of firearm by felon. We have literally just two pieces of evidence for that trial, no witness testimony. The evidence, one of the pieces of evidence we want to introduce is a surveillance video that was introduced during the murder trial. The court will recall that this defendant was found not guilty in, and that the surveillance video shows what appears to be the defendant in possession of a firearm. The sponsoring witness of that video is out of the country and will be out of the country for a month. Under Rule 804 of the Texas Rules of Evidence, I believe the state can use the prior testimony of that sponsoring witness because it was subject to cross-examination by defense counsel. We have secured a transcript of that witness's testimony. We provide a copy of that transcript to Mr. Wilkerson, and we would, if the court will allow us to use that transcript, then there's no need for a continuance, and we'd be ready to proceed with trial.
And, Your Honor, I didn't come prepared to argue that this is the first I'm learning of that unavailability unless Mr. Coleman sent me something yesterday.
I don't see anything. There was I guess, just recently filed a notice of intent to introduce transcribed testimony.
I did file that, Judge, with regard to not only the surveillance video, but also with regard to the defendant's own testimony as well. The court will recall he took the stand and essentially admitted to possessing a firearm that day.
Which murder trial was that? Remind me what I'm.
Romeo Johnson murder trial, it was, the complaint was, the victim was one of the twin brothers, Ronald Barnes. I
Yeah.
can't
Oh,
remember.
yeah.
Brother. You recall the brother was in the wheelchair that testified on behalf. With regard to this,
Give me just a second.
Ronald and Donald Barnes.
Yeah.
And Judge, I know you're reading, but Mr. Freeze, or Judge Freeze did tell me to let you know we're in a 2-day trial.
No, take me just a second.
Yes, Your Honor.
I don't know that this would.
My interpretation.
I mean, under 5, so 804A5.
804B, I think is what I'm referring to.
Well, first is A is the criteria for being unavailable.
Sure.
So a declarant's considered to be unavailable if, so you've got to get one of those 5 to be unavailable, then you go to B. So it's not 1, 2, 3, or 4. So 5 would be the only one possibly. It states that is absent from the trial or hearing, and the statement's proponent has not been able by process or other reasonable means to procure the declarant's attendance or
And
testimony.
that is what we're hanging our hat on, Judge. My investigator, Mr. Bass, is here to testify on the efforts that the state has endeavored in to secure the presence of the sponsor.
Okay,
And I represent to the court that we've been unable, despite our best efforts, to secure the presence of evidence, given the fact that he's out of country.
and so, all right, so if we're gonna get into that, we'll wait and do it at another time. I'll either lunch or like tomorrow morning or something.
Yes, sir.
Because I need to this is probably, we're down to maybe 2 cases, so I will need to make that decision and number the cases. So let's do this, because I would need to hear that information. I think I want to look up a little case law just to make sure. And so you've got 1 witness,
No witness at all, Judge.
no,
Claim
1
is
witness
put-
that's unavailable,
Yes.
and that witness would be
The
sponsor.
surveillance video that purportedly shows the defendant possessing the firearm.
And then
And the other piece of evidence will be the defendant's own testimony. For claiming purposes, Judge, I suspect this trial, at least the state's portion of the trial.
I just feel like without reading that, and I've never had this come up, where in his own trial, introducing testimony seems to violate the 5th Amendment to me.
I don't follow the judge.
Well, I mean, it's almost like you're forcing him to testify
It's a
by
prior-
under on prior. I don't know, let me
It's a
look
prior
into that.
Statement by party opponent, Judge. I mean, he's admitted from the stand under.
I just need to do
under
some
oath.
research that if it's I know if it's another party potentially, it talks about when it's a criminal case, what's given as a witness at a trial or hearing of the current or a different proceeding and is now offered against a party.
I mean, he very well could have asserted his 5th Amendment right during that trial, and he did not, Judge.
Okay, let me look into that. You look into that as well. So
Yes.
804, it looks like we've got 2 things. One is under A with regard to the unavailable
Yes, Your Honor.
witness. The other is under B, which is the former testimony of your client. So let's, I'll give you an opportunity. About how long do you think you guys will be going?
We anticipate finishing this afternoon, Judge. I could come back on the lunch break or,
No, you're in the middle of a trial. I don't want you to have to think about this and do that. I will number the cases tomorrow morning, so let's take care of this. Are you available to come? It won't take long. That gives me some time this afternoon to also do a little research.
I've got another case in the 317th, oddly enough, but I think I can kind of delay that.
If you can come
case
here
to-
first.
Yes, Your Honor.
It won't take us longer than, it'll take 15 minutes. I mean, there's really, I'm assuming your investigator, it will be quick to, testimony as to the unavailability. The other is just legal issues that we all need to just look into.
I'll ask for a trade out since I couldn't stay
Perfect.
here today.
All right, so head back down there. We'll get you back over here,
morning?
tomorrow morning, 9 o'clock.
All right, thank you,
Okay,
Judge.
sounds good. And if everybody gets here a little early, we can start early. I'll try to be here early as well. All right, go back with the bailiff. We'll see you tomorrow.
Come back tomorrow.
Yes, sir. You'll come back tomorrow, and that way we know what's going on for sure if you're going to trial or not. Yes, sir. Okay, so I need to look into those issues. 804. Okay. And so let's see. 9. Mr. Smith, you have Derek Green. Mr. Bruce Smith. Morning. Thanks, sir. Good morning. Are you Derek Green?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
It looks like we're going on lesser, correct?
Yes, Your Honor.
I'm getting there, sorry. All right, Mr. Green, in cause number 25 DCCR 1119, the state has elected to proceed on count one only, and in that count, to the lesser included offense of a Class B misdemeanor terroristic threat from June 19th of 2025. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Smith? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And are you a U.S. citizen? State tenders number 1.
Okay,
It's admitted. Is there any evidence that Mr. Green is not competent?
okay.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time, find you guilty of the lesser offense of a Class B misdemeanor terroristic threat, sentence you in accordance with your agreement to a term of 150 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff. Thank you. Thanks.
Thank you, Your Honor.
Oh, Mr. Smith, we need the attachment because it'll get closed out today.
I was in Orange at
That-
a super aggravated, and they, at the last minute, they
Yeah.
offered 10 deferred. So we
We
came
just need it
directly here.
emailed, we need it emailed,
But we'll email it. We've done that.
today, yeah.
Yeah.
Okay, I was gonna say, if you want.
It's looking like, all right, let's get, Andre Williams, please.
Good morning, Your Honor.
Good morning.
Good morning, sir.
I didn't say good morning to you.
No.
That should have been your own line.
Oh, yeah, we've been, at some point, we gotta go forward. All right, you're Andre Williams. And so Mr. Williams' case is set for trial to begin with jury selection Monday. Announcements?
Judge, I've talked to Mr. Nichols. I'm asking for 30 days. I finally got some clarification on the Social Security records that I'm trying to obtain. They told me how to do it. They'll either let me know they're ready. I send them an invoice if they'll give them to me. They'll certify them. They'll make them court admissible. The court doesn't have to, nothing about an order from this court or a writ or anything like that. They told me it may take up to 90 days, and that was 60 days ago when I think I finally got on the right track with them. So I'll know something, if I don't have them then I just.
I mean, and you believe that they're necessary
I think
for
that
the
they-
trial?
I think, like as the court pointed out last time, they may be necessary in mitigating circumstances.
Mr. Nichols?
Mr. Vasquez has kept me up to date on his efforts there, Judge, and we've discussed trying to resolve the case as much as we can. At this point.
And I guess, would the state at trial be going on the murder?
Yes, Your Honor, that's my
Okay.
intent.
Okay. Does that, I don't want to wait for all of this
No, Judge.
for mitigation on a murder if you elect to go on
No,
the other.
we're going forward on the murder.
Okay, all right, so I will reset, it will be on the next trial docket, which should be more than enough time. That's about 75 to 90 days-ish for our trial dockets. And then at that point, it'll be time.
Thank
It's
you.
getting old and it'll be time to get the case taken care of. Okay? All right, and as always, I've said, if you need any help, let me know.
Thank you, Judge.
All right, thank you.
Thank you,
You
Your Honor.
can go back with the bailiff.